Okay, this time around, we're going to attempt to help us all understand how the legal meanings of words can be changed and hopefully shed some light on why it's done. There'll be a lot of opinion as well as facts in this edition. Feedback will be welcomed and is actually requested from anyone willing to give it. Let's start with what is found in Black's Law for a few words I believe are important in helping us understand the game of words, what I like to call word magic. It may include some of Emmer DeVattle's work. American, pertaining to the Western Hemisphere, or in a more restricted sense to the United States. That the term American included all classes of citizens, native and naturalized, irrespective of where they originally came from. Next, a refresher word, citizen, a member of a free city or jural society, civitas, possessing all the rights and privileges which can be enjoyed by any person under its constitution and government and subject to the corresponding duties. Citizens are members of a community inspired to common goal who in associate relations submit themselves to rules of conduct for the promotion of general welfare and the conservation of individual as well as collective rights. In American law, one who, under the Constitution and laws of the United States or of a particular state, is a member of a political community owing allegiance and being entitled to the enjoyment of full civil rights. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The term may include or apply to an elector qualified to vote in an election. Circuit courts, courts whose jurisdiction extends over several counties or districts, and of which terms are held in the various counties or districts to which their jurisdiction extends, in several of the states. The name given to a tribunal, the territorial jurisdiction of which may comprise several counties or districts, and whose sessions are held in such counties or districts alternately. These courts usually have general jurisdiction. The name of a former system of courts of the United States invested with general or original jurisdiction of such matters and causes as are of federal cognizance, except the matters specially delegated to the district courts. Civil rights, see right, we'll also look at civil. Civil, originally pertaining or appropriate to a member of a civitas or free political community. Natural or proper to a citizen. Also relating to the community or to the policy and government of the citizens and subjects of a state. The word is derived from the Latin civilis, a citizen. Right, as a noun and taken in an abstract sense, justice, ethical correctness, or consonance with the rules of law or the principles of morals. In this signification, it answers to one meaning of the Latin jus and serves to indicate law in the abstract. Considered as the foundation of all rights or the complex of underlying moral principles which impart the character of justice to all positive law, or give it an ethical content. As a noun and taken in a concrete sense, a power, privilege, faculty, or demand, inherent in one person and incident upon another. Excuse me. Rights are defined generally as powers of free action, and the primal rights pertaining to men are undoubtedly enjoyed as human beings purely as such, being grounded in personality and existing antecedentally to their recognition by positive law. Constitutional law. There is also a classification of rights which respect to the constitution of civil society. Thus, according to Blackstone, the rights of persons considered in their natural capacities are of two sorts, absolute and relative. Absolute, which are such as appertain and belong to a particular man, merely as individuals or single persons. Relative, which are incident to them as members of a society and standing in various relations to each other. Rights are also classified in constitutional law as natural, civil, and political, to which there is sometimes added the class of personal rights. Natural rights are those which grow out of the nature of man and depend upon personality as distinguished from such as are created by law, and depend upon civilized society, or they are those which are plainly assured by natural law, or those which, by fair deduction from the present physical, moral, social, and religious characteristics of man, he must be invested with, and which he ought to have realized for him in a jural society in order to fulfill the ends to which his nature calls him. Such are the rights of life, liberty, privacy, and good reputation. Civil rights, such as belong to every citizen of the state or country, or in a wider sense, to all its inhabitants, and are not connected with the organization or administration of government. They include the rights of property, marriage, protection by laws, freedom of contract, trial by jury, etc. Also a term applied to certain rights secured to citizens of the United States by the 13th and 14th Amendments to the Constitution and by various acts of Congress made in pursuance thereof. Political rights consist in the power to participate directly or indirectly in the establishment or administration of government, such as the right of citizenship, that is suffrage, the right to hold public office, the right of petition. Personal rights is a term of rather vague import, but generally it may be said to mean the right of personal security, comprising those of life, limb, body, health, reputation, and the right of personal liberty. Right as an adjective, the term right means just, morally correct, consonant with ethical principles or rules of the positive law. It is the opposite of wrong, unjust, illegal. District courts, courts of the United States, each having territorial jurisdiction over a district, which may include the whole state or only part of it. Each of these courts is presided over by one judge who must reside within the district. These courts have original jurisdiction over all admiralty and maritime causes and all proceedings in bankruptcy, and over all penal and criminal matters cognizable under the laws of the United States, exclusive jurisdiction over which is not vested either in the Supreme or Circuit courts. Also inferior courts in a whole bunch of states here are also called district courts. Their jurisdiction is for the most part similar to that of county courts. District, one of the portions into which an entire state or country, county, municipality, or other political subdivision or geographical territory is divided for judicial, political, or administrative purposes. The United States are divided into judicial districts, in each of which is established a district court. They are also divided into election districts, collection districts, etc. The circuit or territory within which a person may be compelled to appear. Tribunal, the seat of a judge, the place where he administers justice. Excuse me. The whole body of judges who compose a jurisdiction. A judicial court, the jurisdiction which the judges exercise. Judicial circuit, as used in a state constitution, the term referring to the subdivisions of the state, to each of which one judge shall be assigned to exercise therein the judicial power conferred by the Constitution upon circuit courts. Jurisdiction. The word is a term of large and comprehensive import and embraces every kind of judicial action. It is the authority by which courts and judicial officers take cognizance of and decide cases, the legal right by which judges exercise their authority. It exists when court has cognizance of class of cases involved, proper parties are present, and the point to decide it is within issues. Military courts. In England, a court is chivalry and court-martials. In America, court-martials and courts of inquiry are called by this general name. Military law, a system of regulations for the government of an army, that branch of the laws which respects military discipline and the government of persons employed in the military service. Military is distinct from martial law. and that it applies only to persons in the military or naval service of the government, whereas martial law, when once established, applies alike to citizens and soldiers and supersedes civil law. Martial law exists when military authorities carry on government or exercise various degrees of control over civilians or civilian authorities in domestic territory. Martial law is neither more nor less than the will of the general who commands the army. It overrides and suppresses all existing civil laws, civil officers, and civil authorities by the arbitrary exercise of military power, and every citizen or subject, in other words, the entire population of the country, within the confines of its power, is subject to the mere will or caprice of the commander. He holds the lives, liberty, and property of all of them in the palm of his hand. Martial law is regulated by no known or established system or code of laws, as it is over and above all of them. The commander is the legislator, judge, and executioner. Martial law, which is built upon no settled principles, but is entirely arbitrary in its decisions, is in truth and reality no law, but something indulged rather than allowed as a law. The necessity of order and discipline in an army is the only thing which can give it countenance. Excuse me. And therefore it ought not be permitted in time of peace, when the king's courts are open for all persons to receive justice according to the laws of the land. Note, in United States law, martial law is limited by several court decisions handed down between the American Civil War and World War II. In 1878, Congress passed the Posse Comitatus Act, which, depending on the circumstances, can forbid U.S. military involvement in domestic law enforcement without congressional approval. The legality of the implementation of martial law was examined in 1866 in the court case. Through this case, the Supreme Court established that trying civilians in military tribunals was unconstitutional unless there were no civilian courts available. Today, the ability to declare martial law over the United States is not explicitly granted in the Constitution. Despite this, martial law has been declared at least 68 times in the United States. Now, there's much more available on this one, but this is a good stopping point for now. And as always, this is a small amount and leaves much for us to get into, and we will, a little at a time, to help prevent information overload or even burnout. As I've said before, if you spend too much time digging into all of this all at once, you could experience information overload or even burnout. And again, if you have found this to be beneficial in any way, then please visit and like my YouTube and Rebel channels. As always, remember to share across all your social platforms, and most importantly, with family and friends in other countries, as this is a global war. Blessings and much gratitude to all.